My ladies, my lord, I appear on behalf of the appellant.
Yes, Mr Coulson.
My learned friend, Mr Keller, King's Counsel, appears on behalf of the respondent. And my learned friend, Mr Vinnell, on behalf of the advocate to the court.
Yes, Mr Vinnell.
Before we delve into the substance, my learned friend, Mr Keller, has a short preliminary matter to raise with which I am aware and consent, but I'll let him deal with that.
Yes, Mr
Grateful, my lady. You will have noted, I'm sure, that in the course of the hearing before the PCC, certain evidence was received in private under Rule 53 because it were related to Ms Williams' health.
Yes.
The hearing, of course, before Mr Justice Richie was held in public in the usual way, but you may have noted, if you turn please to page 136 of the core bundle. So page 136, Mr Justice Richie made a non-disclosure order in relation to material that was heard below in private in the terms that you'll see at the bottom of 136 and over to 137. Given that this hearing is being heard in public, and of course there are those watching online as well, we would just invite the court to remind anybody in attendance or listening online that that order remains in force. And insofar as it's necessary to do so, that it continues for the purpose of today's hearing. Another part of the reason for emphasising that is that there were in fact both below public and private versions of the judgment. It hasn't been thought necessary to burden this court with both versions. You have the private version. It should be obvious, I think, from the transcript which parts of the PCC's determination are in private. I should inform the court that there's in Mr Justice Richie's judgment, you have the private version. If you please turn just to page 132 of the core bundle. And I won't read it out, but can I just direct your attention to paragraph 145?
I wondered about that.
Yes.
That is the private version, so you don't want us to refer to 145?
145 has been redacted in the version that's been published online and is available
to the public. Bang relevant to ground 3?
Yes.
So how do you want us to deal with that?
Well, I wasn't proposing to necessarily refer to that for the purpose of my submissions. As far as it becomes necessary, if the court has any questions about it or anybody else wants to raise it, we could, I suppose, go into private simply for the purpose of those narrow submissions. That's the way I propose I would propose we do it. But I wasn't intending, I have to say, for the purpose of my submissions, necessarily to raise issues arising from that paragraph.
Well, they're going to be relevant because in the witness statement of the appellant there are redacted passages, and you know what the title on those redacted passages is. And that is, as my lord has said, relevant to the third matter.
It is. It is. Well,
it may be that the way to deal with it is that it's all relevant and it all goes to ground 3.
Yeah.
But that doesn't mean to say it has to be read out.
No, right.
You can take us to the passages and ask us to read them.
Quite.
And make your submissions around them. I don't think that should cause undue difficulties or hamper the other parties.
No, I'm absolutely content to proceed in that way.
Yes, well, we'll deal with it like that. So I'll just re-emphasise for anyone online or anyone that's any reporters that are here is that Mr Justice Richie made an order on the 7th of June 2022, which is available and continues to bind the parties and anyone observing this, which makes a non-disclosure order in relation to certain expert and factual evidence that was received in private. And that evidence is to continue in private, and anyone wishing to report in any form anything to do with this case is referred to that order specifically for the details. Yes, anything else that we need to do by way of housekeeping?
No, thank you, my lady.
Well, if I can tell all of you that we've had an opportunity of reading all the papers, we've read the skeleton arguments, we've tried to weave our way through the regulations, and so you can take it that we're familiar with the issues in the case.
Thank you very much. Well, in which case, I'll, as it were, jump to the heart of it. As you appreciate, the issue from which everything else flows, including ground 3 in our submission, is whether the NHS Contract Regulations 2005 forbid mixed fees known as top-up fees. And it's important we all understand what is meant by that nomenclature in our submission, and I do not believe this is controversial insofar as the appellant and the respondent is concerned. What is meant by top-up fee is the dentist accepting, in this instance, a private fee for an all-ceramic crown, which was part of the treatment provided by dint of the NHS contract. As you will have appreciated from our skeleton argument, the profession as a whole, up until the judgment of Mr Justice Richie, was clear in its understanding that top-up fees or mixed fees were forbidden. Both experts on either side and indeed the respondent's educational supervisor were clear in that. Now, of course, that's not determinative, but it does, in our submission, demonstrate just how important this question is to the profession and indeed to those instructing me, the regulatory body, the General Dental Council.
Ms Johnson, if it was so important, why weren't those documents before the committee at the original hearing?
Because it was agreed between the parties as to what those documents meant. There was no dispute between the parties as to the interpretation. And as you will have appreciated, my learned friend's client accepted that top-up fees were inappropriate. The sole question before the PCC was one of dishonesty. And in an attempt which I would suggest is admirable to try and reduce the issues and the burden of paperwork on the committee, the charging and contract regulations were not put before the committee because of the admissions in the case.
Well, it may be at the next hearing these matters arise again. Further thought will be given to core documents and whether they should in fact be before the committee.
Yes, well, of course, what's happened since that decision will instruct those who conduct these cases in the future. But I think the decision not to, maybe with the benefit of hindsight, may have been misplaced, but it was certainly done in an attempt to narrow down the issues. As will be apparent from all the skeleton arguments in this case, the decision for the court is really one of a question of fine statutory interpretation. And there is no case law, there are no explanatory notes which assist. And so therefore what I will seek to do is to test the various interpretations of the regulations against practical dental examples, and I hope thereby seeking to persuade the court that the appellant's interpretation of the regulations is the correct one. Before I do that, one final matter by way of background, if I may. It's self-evident that the provision of NHS dental treatment requires regulation so that there is no ambiguity as to the charge required from the patient or indeed that claimed from the NHS Business Service Authority. And any system which introduces what can perhaps be described as an element of commercial discretion in relation to top-up fees would, in our submission, risk dentists prioritising business needs over the provision of dental care. So against
I
that...
think we can agree that ambiguity is a bad thing. The decision for us is whether that's what these regulations achieve.
Yes.
A clear and unambiguous position.
Yes.
Is that your submission?
My submission is that perhaps the regulations could have been drafted a little more carefully so that there was mutual consistency, but my ultimate submission is that they are clear in their meaning, and I will seek to persuade you of that now, if I may. So clearly the starting point it is Regulation 22 of the contract regulations. May I take you to the core bundle and a page 142, paragraph 17. This is contained in the appellant skeleton argument.
Paragraph?
It's page 142, paragraph 17, towards the top of the page. And this sets out the National Health Services, General Dental Services Contract Regulations, hereafter Contract Regulations 2005, and in particular Part 5, Regulation 22. And if I may be permitted just to read a small part of it. 22 subsection 2 reads as follows: the contractor shall not, either itself or through any other person, demand or accept a fee or other remuneration for its own or another's benefit from, little a, any patient of its for the provision of any treatment under the contract, except as otherwise provided in the NHS charges regulations. And just pausing there, if I may, in other words, what that section is saying in our submission is that when a dentist is providing treatment on the NHS, the only fee which can be charged is one provided for by the charges regulations. And we will, of course, note that this is a mandatory requirement given the language of Section 2. And as you will have appreciated, depending on their financial means, some NHS patients receive their dental treatment entirely free. Others have to pay a contributory charge. And those charges, rather complex banding of charges depending on the nature of the treatment, are set out as referred here in the charges regulations. And it's perhaps of note that although the charge is claimed from the patient, it doesn't actually go to the dentist. It goes to the state. And so in our submission, this as a starting point, the language of Regulation 22 is clear in that the only exception on the ban on accepting a fee for work conducted under the NHS contract, and of course that's critical, is that provided by the charges regulations. And again, picking up on my Lord's comment, as a matter of statutory analysis, in our submission, if there was any other exception, that would, we suggest, be made as explicit by the legislators as Section 2, subsection 2 is here.
Ms Johnson, that I completely understand that. Can you just help me with this? I've not waded my way through all of the charges regulations, but since that is, as you rightly say, the only express exception here, can you give me an example in the charges regulations of something that's an exception?
Well,
I mean, I looked at the stuff about banding for crowns,
yes.
so band 3, but how does this work in practice? What is there in the charges regulations that's an exception to the, as you call it, the ban?
Well, the charges regulations in themselves provide the exception, but the exception is quite complex because, as you will have seen from the charges regulations, it depends on, well, first of all, the status of the patient as to whether there's any fee to be paid at all under the charges regulations. And then if there is a fee, that is dependent upon the nature of the treatment. So that's the way in which those regulations are constructed,
So the
but they in
status-
themselves, in my submission.
Okay, so the status of the patient, you said their financial position, I understand how that could be an exception. Which regulation of the charges regulations is that?
It's regulation 3. I don't know if you have those, but
Page 127 in the authorities.
yes.
Yeah.
Charges for the provision of dental services sets out the charge of the amount provided for and the calculation. And if you look at subsection 2, no charge shall be made and recovered under paragraph 1 in respect of, and then there's a series of subsections which sets out those categories whereby a patient will be exempt. And then under calculation of charges, then that delves into the various bands that are
The bands are, that's the charge.
the band is the charge, yes.
So what we were looking for is a reduction or a different charge payable. I mean, these are no charges made and recoverable in the case of a prisoner.
Yes.
Understand that?
Yes.
But we were talking about financial means. I don't obviously see that.
Well, perhaps I've not explained it as clearly as I could. If one isn't subject to that which is set out in little 3, charges for the provision of dental services, then one has to pay a banded charge dependent on the nature of the treatment received.
Yeah.
So this, looking at this regulation then, that doesn't seem to exclude the prisoner, we see that. It doesn't seem to exclude, for example, someone in receipt of a universal credit.
It doesn't say that on its face. May I come back to that? Because I think those behind me might be able to help slightly as to, I think I've set a hair running talking about financial means.
It's entirely my fault, but it's important because your case is, which I completely understand, that this is the only exception.
Yes.
So if it is the only exception, it'd be quite good to see how it worked as an exception to the ban that you've introduced by referring to 22.2, which I completely understand. I completely understand that submission that says, here is the ban, this is the only exception.
Yes.
So it'd just be good, and I'm sure it's my fault, and as I say, I've not
it won't be that.
I have not waded through all of the charges regulations, but I kept thinking, well, hang on a minute, these are the bans, these are the charges that will be being paid for the work in the bans. How's that an exception to the ban? You see what I mean? It was just, I couldn't quite work that out. But as I say, I'm sure that's my fault, and I'm sure that there is some worked explanation for that as to why this is an exception to the ban. But as you rightly say, the only exception.
Yes, may I come back to that in a moment, but I hope I'm on reasonably secure territory in that when one reads Regulation 22, the only explicit exception is the charges regulations, albeit they are, perhaps we can all agree, somewhat convoluted. But if I may, I'll come back to that.
Yeah.
Just before you're just getting a note, I think.
Would you forgive me?
No,
Thank you. Yes.
What I was going to just ask is, the first step, it seems to me, on reading A, is you've got to decide if it's treatment under the contract.
Correct.
And only if you've identified whatever it is as treatment under the contract, is there then an exception?
Yes.
That's
Yes.
correct,
That
isn't
is
it?
correct, yes.
And are you going to take us to where we find out how you decide whether treatment is under a contract, or is everything under a contract?
Everything is under the NHS
Right.
contract, unless a patient decides to have dental treatment conducted privately. In this case, there was no issue as to the majority, if I can put it that way, of the treatment was under the NHS contract. It was treatment being provided under that umbrella. But one part, I would suggest part of that was isolated by the dentist and a top-up fee charged. But if one looks at the treatment as a whole, that was under the NHS contract.
Thank you.
My Lord, I've been very helpfully by those sitting behind me reminded of, in the charges regulations, if one goes to section 7, that is headed conditions for exemption under the Act.
Page 134.
Thank you, my name. And again, I'll come back to this in due course, but that may assist my Lord's question.
We've taken you out of turn. Do
No,
you get
no,
that?
well-
No, I think we need to ask questions, but on the other hand, when you're trying to work your way through statutory interpretation, you need to
Well, one should be able to
work
do
it
both.
through. Well,
But
you are.
I will come back to that section 7 in a moment, if I may. So, Regulation 22, I would hope so far so good. The problem in this case arose because Regulation 22 has to be read in conjunction with Schedule 3, Part 2, Paragraph 10, and that is set out on page 143 of the core bundle at paragraph 18.
Sorry, what page was that?
So core bundle, page 143, paragraph 18.
I'm working from the authorities bundle, actually.
Ah, well.
It matters not, it's the same regulation.
Yes, same regulation. So this is headed mixing of services provided under the contract with private services. And then paragraph 10 says this, subject to subparagraph 2 and various other aspects of the legislation which are not relevant in this case. A contractor may, with the consent of the patient, provide privately any part of a course of treatment or orthodontic course of treatment for that patient, including in circumstances where that patient has been referred to the contractor for a referral service. Again, looking at that paragraph 10, in our submission, the clear and ordinary meaning of that, and we'll come to what a part means in a moment, but a clear and ordinary meaning of that is that a dentist can isolate a part of the course of treatment, that's to say remove it from the NHS regime and charge a private fee. But what he cannot do is, as it were, have this hybrid in relation to that part of both NHS and private. And I think it's common ground that the removal or the isolation of part of a course of treatment and paying for that privately is common and is accepted. There's no difficulty about that, because that's what Schedule 3, paragraph 10 allows for.
So the position is this, that the patient embarks on a course of treatment with a dentist, and in respect of any part of that course of treatment, the patient and the dentist can agree to remove it from that NHS course of treatment.
Yes.
That's it.
Yes. Yes.
But you can't mix and match.
But essentially, my lady, that is our case. You can't mix and match. And of course, it is notable in paragraph 10 that there is no reference there to the NHS contract. Contractor may provide privately any part of a course of treatment. And again, that is sits, we would suggest, comfortably with Regulation 22. Now, there are really, perhaps, as I identified by Mr Vinnell, two aspects to this. First of all, whether paragraph 10 is in itself a further exception, and secondly, what does a part of course of treatment mean? Now, as to the first of those points, it's right that the judge on appeal seems to have regarded paragraph 10 as a further exception. But as Mr Vinnell very helpfully sets out in his skeleton argument, of course, paragraph 10 is part of the same contract regulations. It's not a further part of the express exception provided by the charges regulations. And in our submission, that is significant. And we would submit that Regulation 22 and Schedule 3, I'm sorry, I don't know, there's a slight...
I don't know what it is.
Sounds like it's in the roof.
Is it interfering?
No, I as long as it's not interfering with the court, no, I can happily go on. It's not me.
I think it's the transcribers that will be doing something.
Sorry.
I think it's transcribers trying to fix something, so it's because the way he was reading is that just the transcribers. Yeah, because the way he was reading is I think they're just kind of flicking with it right now and just looking for what it's on their end.
So is it coming through loudspeakers then?
I think so, yeah. They're trying to do something.
Well, I think we'd like them to stop doing it while we're trying. Could you try? If necessary, I'll speak to them if it's difficult for you. Apparently the transcribers are doing something.
The transcribers in this case.
We haven't got transcribers in this case. I certainly wasn't asked for permission. That on,
Yes,
Johnson,
of
and
course.
we'll see how we go. If it becomes very distracting, we'll have to.
Of course. What I was submitting to the court is that Regulation 22 and paragraph 10 must be read in our submission consistently with each other, and moreover with the overriding purpose of the National Health Act. And if I may invite you to go in our skeleton argument, so the core bundle page 146, please. Paragraph 25 sets out the primary legislation and section 2 of that says this in relation to the Secretary of State's duty as to health service. Section 2, the services so provided shall be free of charge except insofar as the making and recovery of charges is expressly provided for by or under any enactment whenever passed. So again, those words, recovery of charges, expressly provided for. In our submission, any attempt to infer a further exception somehow buried in Schedule 3, paragraph 10, would not only be inconsistent with Regulation 2, but would also be inconsistent with primary legislation. So that brings us on to the second and perhaps slightly more complicated aspect of this. What is meant by a course of treatment, part of a course of treatment in relation to paragraph 10, Schedule 3.
We know what's meant by a course of treatment because that's defined.
It is defined, my lord, absolutely, and I've set it out.
Yeah.
My paragraph 20, core bundle page 144, and my lord, it is of course absolutely right that that's the starting place for analysis of this question. And if I may just remind the court of two aspects of that definition. A course of treatment is defined here, part is not defined anywhere. But a course of treatment...
Sorry, Ms Johnson, my apologies for interrupting.
No.
When you say part is not defined anywhere, are you referring only to those regulations or generally?
Well, generally, it's certainly not defined in either the charges or the contracts regulation. And I've not been able to find any, as it were, useful assistance from another source. So we're left with a definition of course of treatment, and as I hope I'm going to demonstrate, when we look at the practice of dentistry, it will be clear that a part, such as a crown or a filling or an extraction, cannot be further subdivided, but I'll come to that in a moment if I may. But course of treatment, set out on page 144, paragraph 20, means, and I'll just jump, if I may, to little b. Well, no, perhaps I should deal with it all. Little a, an examination of a patient, an assessment of that patient's oral health, and the planning of any treatment to be provided to that patient as a result of the examination and assessment, and little b, the provision of any planned treatment, and that's further embellished, and then little 1, and we would submit this is important, each and every component of the planned treatment has been provided to the patient. So it's a little unhelpful because the course of treatment definition talks about each and every component, whereas paragraph 10 of Schedule 3 talks about part of a course of treatment, but we would submit that although the language is not identical, it in effect means the same thing.
I mean, linguistically, it possibly doesn't, because if a course of treatment is defined as meaning each and every component, then you read that into 10.1, then you've got any part of each and every component of planned treatment.
Well, that is what...
It couldn't be more micro on that basis.
That is what is being contended for, but that one has a further subdivision. So as my lord has said, you've got a course of treatment that has a series of components. Let's say a component is a crown, and then part of that component is what? Drilling the tooth to prepare for the crown, making the impression, putting a temporary crown. My lord is absolutely right to describe that as micro, but I'm going to, I hope, suggest that that is a granular further definition, which just, one, doesn't work in practice, and two, would lead to potentially some rather unfortunate policy consequences. And clearly that there's no authority or nothing that can be pointed to suggest that very granular subdivision is what is meant when one looks at the course of treatment and paragraph 10. And indeed, to be fair to the learned judge below, he didn't seek to further refine and define part of a course of treatment.
So your submission is that's the same as each and every component?
My submission
broadly
is,
speaking.
yes, broadly speaking. It's infelicitous language, but broadly speaking, that is exactly right. Now, going back to what was at issue in this case, that is to say, the giving and fitting of a crown. Let's just look hypothetically at what a typical course of treatment might be. And as is reflected in that definition, a hypothetical course of treatment might be an examination of the mouth, possibly some x-rays, a filling on one tooth, an extraction of another tooth, and a crown fitted on a third tooth. Each of those parts or components are necessary to secure the patient's oral health. Now, this is where it gets a little complicated, because if all of those parts, take my hypothetical filling, extraction, crown course of treatment as an example, if all of those parts or components are provided on the National Health Service, then the dentist can, first of all, charge the patient a band 3 charge, because the crown attracts the band 3 charge, and as you'll appreciate, the band 3 is the highest charge. A filling and an extraction are lower charges. So if the crown is being provided on the NHS, a band 3 charge can be levied.
And who gets that?
That goes to the state.
I was going to say that's the work is done by the dentist under the contract.
Yes.
And the band 3 charge is paid, effectively reimbursed to the state.
Correct. And the dentist's remuneration, and one hopes we don't need to get into too much detail about remuneration because it is very complex, but in my hypothetical example, if the crown is provided on the NHS, then the dentist remuneration is dealt with via what's called units of dental activity. It's a very ugly phrase, but UDAs, units of dental activity, and a dentist contract. A dentist is expected to provide X number of units of dental activity per annum, and a crown represents 12 units of dental activity if it is being provided on the NHS. And so my hypothetical example, Crown provided on NHS triggers two things. The levying of the Band 3 charge and the use of 12 units of dental activity for the provision of that charge. And that's going to be important when we look at what happens with this purported hybrid. Now, again, looking back at the definition of a course of treatment, which requires each and every component of the planned treatment under the NHS, in our submission it is clear that a dentist cannot claim NHS remuneration for treatment if any part of that treatment has not been provided on the NHS. So again, to use my hypothetical example and turn it round, if the Crown has been removed from the contract and is being paid for privately, then the dentist is first of all not entitled to levy a Band 3 charge because the Crown has not been provided on the NHS, and the dentist is further not entitled to claim 12 UDAs because the Crown has not been provided under the NHS. And that's where the problem lies in seeking to further define or divide part or component of a course of treatment, because that would make a mockery of those two aspects of remuneration which I've identified. Because what happened in this case is that the Band 3 charge was levied plus the extra £65 for the ceramic crown, and indeed the requisite 12 UDAs for the provision of the crown were also claimed. So just pausing there before we look at the problems that this subdivision may lead to, in our submission, it is clear, it is consistent with the regulations, and indeed, for what it's worth, it's been practice ever since these regulations came into being, that part of a course of treatment can be removed, can be paid for privately, but part must mean that in its entirety. Because again, if one uses the example of a crown, and I've touched on this, and I'll use another couple of examples in a moment, but again, if one uses the crown example, as I've said, there are various aspects of preparation, using an anaesthetic, using a drill, making an impression, sending it to the laboratory, fitting a temporary crown, and then eventually fitting the final product. That's the package, which is the part of the course of treatment, which is fitting the crown. When one sees a typical treatment plan, as I've said, and if the court would like to see one, we will be able to provide one, but I don't think it's controversial. A treatment plan for the patient will say examination, x-ray, filling, crown. It won't say subdivide crown into use of anaesthetic, use of drill, making impression, so on and so forth. It would simply say provision of crown, upper left 8, or whatever it may be. Now, if one sought in our submission to dismiss or to reject the argument that we contend for, and to suggest that you can subdivide a part or a component, we would submit that such a reductive approach would just be illogical and just wouldn't work in practice. Because, for instance, Mr. Vinnell posits a subdivision of labour and parts. It is a very clever argument, not actually one that the judge at the lower court decided was the foundation for his conclusions. But if we just take that as an example, how do you divide that? How does the patient know which part is on the NHS and which part it is private? And how does that sit with those charges
But if
regulations?
If you're the patient,
Yes.
you go in and you need a crown. So you've had the bad news, and there's various different kinds of crown. There's porcelain ones, and there's the ceramic ones, and the ceramic ones, for reasons that I don't understand and don't need explaining to me, ceramic ones are cost more for whatever reason than the porcelain ones. So I can well see that a patient would think, oh fine, well obviously I get my NHS crown, I get my treatment and my provision of a crown on the NHS. But the NHS, quite understandably, straitened times and all that, you know, they'll only say a porcelain crown's absolutely fine, that's what you get. But if you want the ceramic version, then there's a top-up fee, you have to pay a bit extra for that. And many a patient would say, no thanks, porcelain's lovely. And some will say, no, I, you know, only shop from Waitrose, yes please, I'll have a ceramic crown. So I think when you're talking about division of how on earth could you divide it up logically, it seems to me that from sitting in a patient's seat, that there is a certain very easy logic to it.
There may be a superficially attractive logic to that, and if I may, I'll come on to why that approach, that's a top-up fee, and how if one looked at that across the board, how that would actually lead to potential further health inequalities and disadvantage to a patient. If I may, I'll come to that policy question in a moment. But of course, in this case, the patient was being charged for the provision of the crown on the NHS, the band 3.
As everybody would be, whether it's porcelain or ceramic.
Absolutely. And then invited to have the top up. That's one part of the equation. But of course, the other part of the equation is from the dentist's point of view, that dentist is recording, as I've already said, 12 units of dental activity for which the dentist is remunerated, when in fact those 12 units of dental activity do not include the provision of the crown on the contract, because the provision of the crown has been turned into this hybrid. And if one goes back to...
Do you get the same number of points, UDAs, if for a porcelain crown as a ceramic crown?
You get the same number of points, yes. Yes, you get the same.
So on my, still sitting in my patient's chair,
yes.
So far as the proper and honest remuneration of the dentist is concerned, they get the same amount.
They do.
Regardless of whether it's a porcelain or it's ceramic.
They do, but they haven't completed every part of every component, to use the language of course of treatment, every component of the planned treatment on the NHS. Because what they've done is effectively the dentist has done all the preparatory work on the NHS, but the provision of the crown is both on the NHS and privately. It's been melded.
They've still got a crown on the NHS.
They've still got a crown.
Which is still being fitted by the dentist on the NHS.
Yes, but
the difference is top up? I mean, I'm being devil's
Yes,
advocate,
no,
I'm
of course,
testing
of
this
course,
out.
of course, and I'll come to the,
Is the different, whether it's ceramic or porcelain?
absolutely, but first of all being legalistic before coming on to
Yep.
the ramifications of this, if our interpretation of the regulations is correct, legalistically, that is in contravention of the regulations.
It's in contravention of the regulations if you are claiming a band 3 fee charge. But if, taking it just one step away from the facts of this case, if the dentist were to fully consent to the patient and say, right, I can do all the preparation on the NHS, but as to this last bit, on the NHS I can only provide porcelain, you want ceramics, I'll do all the prep NHS, save the last bit which I separate out, you pay for the ceramic. What stops the dentist, not on band 3, but claiming UDAs for the preparatory work?
Well, as I've indicated, the UDAs, and I'll be corrected if I'm wrong about this, but the UDAs don't discriminate between the type of crown, but it is for the provision of a crown.
No, I'm moving away from the band 3 charge, Ms. Coulson.
Yes.
I'm really going back to the argument, can you split the parts?
Yes.
My provisional view is it depends how you consent the patient.
Well, clearly that's.
But what stops a dentist having properly consented a patient and having agreement that the preparation work can be on the NHS, but that final part, the provision of the crown, will be private? What stops the dentist claiming inappropriate banding for the preparatory work?
Because in our submission, a practical and logical definition of part or component is, as I've submitted, the completion of the treatment, the planned treatment. And in my lady's example, what is being posited is the preparatory work, an element of the treatment would be under the contract, but the final aspect of that treatment would be private. And that means that under the contract, in my lady's example, the dentist would not be completing each and every component of the planned treatment.
Well, it depends how the dentist describes the planned treatment to the patient. And if the dentist says to the patient, I will do X, Y, and Z, which takes me up to the point of completion until I provide the crown, that could be argued to be a course of treatment. Is the preparatory treatment standalone in itself, and then separately there is the provision of the crown?
Can we test that with other dentistry examples? Because the division of part, effectively what my lady has suggested is a sort of a parts and labour type split. But if we look at perhaps another couple of hypothetical examples.
Just before you move on to that,
yes.
can I just
Yes.
ask one question arising out of that so I have a complete picture?
Yes.
So the 12 UDAs, is that broken down in you know, God forbid that we should be now going to the dentist remuneration regulations wherever they are, but just in the broadest of terms, is that broken down as to, you know, one for examination and two for an x-ray, or is it just, everyone's shaking their heads behind you, or is the way it's done is just, you know, crown equals 12, billing equals 4?
Yes, I believe that is, and I will get in broad terms, I think that's right. Yes, attached to the ban, not the treatment, but in broad terms, that's right. Can I go back to testing this?
Of course.
By dint of one or
Your
two
hypotheticals, yeah.
other examples, this potential division of, as it were, labour and parts. Look at a filling as an example, usually done in a single visit, usually using amalgam. And what does the dentist do? I don't want to be too reductive, but effectively makes up the paste, squirts it in the cavity in its most basic terms. Now, hypothetically, what if a patient says, well, I don't want to have an amalgam, I want to have a gold filling? In what's being contended for, how is the dentist and the patient going to divide, in that example, divide parts and labour? It's effectively one course of conduct, course of treatment. How does one put a price tag, as it were, onto the labour part of it, as opposed to the gold filling part of it? And again, the filling, forgive me, the filling is, the treatment is not complete until the substance is placed in the mouth.
But doesn't the same argument apply to the filling as would apply to the crown? We do very good amalgam fillings on the NHS. If you want a gold finger gold tooth, then it's an extra £150.
Well, again, that idea has to be tested against the various ways in which remuneration is claimed and paid for. Now, in that filling example, a band 2 charge is levied for an examination and a filling. Now, if the dentist has only provided, let's say, the examination on the NHS, but the filling is a gold filling, and that's been hived off, how is that consistent with the bans that are being levied? I think if I can distill it in this way, and I'll use one more example, our fundamental submission is that if you subdivide in the way that's being contended for, that will cause real practical difficulties for the way in which remuneration is secured and paid for. Moreover, that's the primary concern, that it just doesn't sit practically with the charges regulations. But another concern, if one micro divides it in this way, let's say you have one part on the NHS, one part privately, in this labour and parts division. What happens if something goes wrong? Where does liability lie? Does it lie in respect of the NHS part of the course of treatment, or does it lie with the private? Now, I don't want to be too esoteric, but one can predict how there may be problems with liability if you're subdividing a part of a course of treatment into this, to use shorthand, labour and parts division. I mentioned really two reasons why we submit that this is an erroneous definition. One was how that intersects with the financial aspect of it, but another is policy reasons. If the regulations were interpreted in the way contended for, that's to say, allowing for top-up fees, then we submit that it would fly in the face of the fundamental principle of free dental services provided on the NHS. And why do I make that submission? Well, let's go back to this case and the provision of ceramic crowns. If as a matter of practice and policy, ceramic crowns, top-up fees were permitted, and therefore ceramic crowns could be achieved in this way, well, that has the following potential consequence in a dentist choosing never to provide a ceramic crown on the NHS, even when it is clinically justified, let's say for a front tooth, or where the psychological state of the patient is such that there can be clinical justification for it on the NHS. If the interpretation of the regulations allowing for this subdivision of part, that would, and therefore allowing for top-up fees, well, that would it not allow dentists to regularly avoid the extra costs involved in this example, thereby actually acting to the detriment of patients in the future? One talks about £65 as a top-up fee. Well, for many people, £65 is a lot of money that they simply cannot afford. But if one enacted a scheme which allowed dentists to do this regularly and in accordance with the regulations, then one can foresee how that could be abused to the detriment of patients.
Can we just talk around that?
Yes.
The first point is, I know you say that full ceramic crowns are covered by the NHS contract.
Yeah, you can, yes, yes.
What's the precise provision that allows for that?
Well, they are found in the band 3 charges, but it's whether the
Well, they're not as ceramic crowns, they're not.
Let me check that. I believe that 117.
I mean, I have the page 157 in the authorities file.
Sorry, which section? I'm on a different.
With Schedule 3, Band 3 charges, which you summarise, I think, in your skeleton.
Yes.
It's divider 3 in the
At
authority.
page
Yes,
147.
Yeah.
And it's 157 in the authorities.
Yes, thank you.
The word, we get crown in porcelain, synthetic resin and other non-metallic crowns. And then there are various other provisions, including, my researchers show, little I, now deleted, which was quite a wide category.
Crowns in other materials.
Yeah, but that's deleted. That was deleted in 2006. So actually, why are ceramic crowns covered by the contract? Which is the provision that catches it?
Um,
I'm sure those sitting behind you know, because
They
it's the
will
critical
know.
question
They
in the
will.
case.
They will. Would you give me one moment, because I think I've made a slight error in saying what I said. May I just turn to those
Yeah, of
behind
course,
me, because
of
I don't
course.
want to mislead the court. I'm getting a little list of, increasingly lengthy list of matters to come back to my lord on. I absolutely take that point, and can I check it and revert to you?
Okay.
Um,
So that's the first question,
Yes.
which I think arises pretty directly in this case.
yes,
Indeed, you say at paragraph 28, as is clear from Schedule 3, a full ceramic crown is available on the NHS.
yes.
But
You need
I said
chapter
why.
and verse,
Oh,
yes.
well, I just asked why. But okay, let's assume that that is covered by the NHS contract. I'm assuming that a dentist can't therefore refuse to provide it.
If it is clinically necessary to secure the patient's oral health, that is the test that the dentist will employ.
Okay, so he can't refuse, or she can't refuse, if it's clinically necessary for the oral health
Yes.
of the patient. Understand that. In this case, it wasn't.
It was not regarded by the dentist as such,
Right.
yes.
So the dentist could refuse to offer that treatment on the NHS.
Yes, as long as that test is properly applied, yes.
So, but the dentist could agree to provide that privately.
Yes, in our submission in its entirety, but yes, we know where the contested
Yeah.
ground is.
So, leaving aside the complications with how the dentists are remunerated in practice, leave that aside. There's a risk, firstly, isn't there, that if a dentist can say yes or no, if it's not clinically necessary, then he may refuse me, but he may say yes to my friend who lives down the road who goes to another dentist.
Well, that's a theoretical possibility, but one would hope that there is a...
Well, I understand that, but that seems to be the area you may get into if you've got something which can be refused if it's not clinically necessary. And then the other policy point that I wanted to put to you was, as I say, again, forgetting, which I completely understand, the complications of how dentists are remunerated. What's wrong as a matter of principle with both me and my friend down the road having the benefit of the amount that would otherwise be charged to the NHS, and with me simply paying an additional amount because that's what my dentist has charged me?
Because if one takes that as a principle, yes, it's superficially attractive for the purposes of discussing crowns, ceramic crowns, as we are in this case. But if one steps back and looks at the potential broader application of that principle, it could have the unintended consequence of patients being deprived that which they would otherwise have received under the NHS.
But if we're saying that this is not clinically necessary, they could have been deprived of it anyway, because you say the dentist can simply say no.
Yes, but again, I appreciate this case is about crowns, but I'm keen to try and use other examples because I think that's a way of testing the principle more completely. And can I put another example to the court of NHS bridge work? Now, on the NHS, a dentist will make an examination, take impressions, and offer a bridge of a perfectly satisfactory standard. But if this subdivision and top-up fees were allowed, then in that example, a dentist could say, well, look, I'll provide under the NHS a reasonable and satisfactory bridge, but if you want to pay £100 extra top-up fee, well, I'll provide a slightly superior bridge that bridge, which would have always have been available on the NHS. So I think that's perhaps a little convoluted way of saying or submitting that if one allowed for a regime of top-up fees, an unintended consequence would be that what's provided on the NHS would be reduced down to its minimum, thereby introducing an element of commercial discretion on the part of the dentist, which broadly and long term is not going to benefit or may not benefit the patient. So that's the way we would argue that policy question.
I see that, but that seems to me to be at least potentially inherent in all of this where it's not clinically necessary, so that the dentist is entitled to say no, but I'll do it privately. And you're already, you've opened the door to commerciality at the outset.
But in my bridging example, let's call it the superior quality bridge is clinically necessary and therefore is available on the NHS. But if you introduce a system of permitted top-up fees, which we would submit would be potentially liable to abuse, and how is that going to be controlled, then in my bridging example, the dentist could say, well, I'll provide you with this superior bridge, which was always available anyway, for a top-up fee.
But if a dentist, if it's clinically indicated, your bridge or your type of filling, gold filling would be clinically, but certainly ceramic crown would be. What you're saying is the policy imperative is to avoid dishonest dentists who won't comply with their professional obligations. So what you're saying is the policy imperative is dentists can't be trusted to recommend the appropriate clinical course of treatment because they'll want to get their £60 or their £100 extra.
Well, I would...
But I mean, that's what it is, because it does depend. Because if you're saying it's clinically indicated, but they won't do it because they're introducing a commercial aspect, and so they can charge for that part of it, that would be wholly improper professionally and put them before your board. And I just worry about a policy imperative that says it's all about stopping our highly qualified, internationally applauded dental practice profession from being professionally dishonest.
Well,
and that's a worry to me if that's the approach.
No, I understand that, but the problem with interpreting the regulations as permitting top-up fees is put the question of the dentist's integrity to one side. That is an entirely unregulated, uncontrolled environment. Forgive me.
But is it? I mean, what are we talking about in real terms? Well, we've had our bridge, we've had our fancy filling, and we've had the different crown. But I mean, are you talking about a complete huge array of different treatments this would apply to, or are we talking about a very small number of cosmetic, what are essentially cosmetic issues? I mean, please tell me, because I just don't know.
Well, if top-up fees were to be regarded as permissible, then that would go beyond mere cosmetics, because that's perhaps the point. They're not defined. So theoretically, a dentist could encourage a patient to pay a top-up fee for any part of that course of treatment. So it would not be confined just to cosmetic aspects of dentistry, not at all. And that is the concern, that it would cover a wide gamut of dentistry, not just these.
It would cover a gamut of dentistry where whatever it is not clinically indicated, but someone may wish it for other reasons, either cosmetic or what other reasons?
Well, the question of clinical necessity, again, you don't, that can't just be divided into that which is necessary to secure the health versus that which is cosmetically more attractive. My bridge example is an example of that. One can get a perfectly good, superior quality bridge on the NHS, which is clinically necessary. But a dentist could argue, well, what's clinically necessary is one which is perhaps not as superior in substance or whatever. But if you want the super duper one, then you pay a top up fee, whereas you would always have that superior one, which is clinically necessary, on the NHS.
Back to the integrity of the dentist.
There is an aspect of integrity here, but the submissions are made to ensure that the profession is not presented with a further complicated scheme over and above the regulations, which, as I've said, it is not controlled. So there's nothing to stop a dentist charging £65 in this instance, or £165. It's the problem of that. If that was entirely in the private arena, well then,
So be it.
so be it. If you want to pay £1,000 for your crown fine, but it's where you're dealing with NHS patients and introducing this hybrid, attaching that to the contract.
Paragraph 10 does. I mean, your submissions are all, some of your submissions almost say paragraph 10, or we don't have to worry about it. Paragraph 10 is the regulation, and I completely follow your point that has to be read with the ban in Regulation 22. But we have to try and make sense of something which is introducing effectively the unregulated private service.
Yes, but paragraph 10, absent the contract, separate,
Yes.
entirely
Which the
separate
dentist
to the
can duck
contract.
out of at any time if it's not clinically necessary.
To use
Yes.
your word, remove.
Remove, yes. That's not controversial that it can be removed. The question is whether it's removed in its entirety.
The question is how much of the tooth you're removing.
Yes.
Sorry, I realised early on I was going to do that joke. So
We're just very relieved he's got it over with.
and I lasted till 11:45. Quarter to 12.
Quarter to 12.
But that is the point, isn't it? It's how much, where the dividing line falls.
Well, that is absolutely, my lord, that is the point. And our argument taken to its most basic is, I've sought by giving you various practical examples to demonstrate that because a course of treatment has this whole series of aspects, to use a different word, to subdivide and introduce the regime of top-up fees, which of course wouldn't necessarily just be for the physical part, because again, another example might be that a patient would like a little bit more time, would like a longer appointment. So does time spent conducting a treatment come into this subdivision? One can take it further, equipment, so on and so forth. The problem is, if you set this up as a principle, it's not as simple. It's not like taking your car to the garage and it's parts and labour. It's not as simple as that. It's these multifarious layers of conduct and physical thing which makes up part of a course of treatment. And it's that which we suggest potentially would lead to mayhem for dentist and for patient.
Ms Johnson, this is not a cynical question. Can I just make that clear at the outset? But is a real problem this morning that no one has challenged the hitherto interpretation of these particular part of the regulations?
Yes.
Yeah, thank you.
Yes.
And so when you describe mayhem, it's going to cause mayhem amongst those who sit behind you and those who work within the profession who have gone along such they didn't even bother to bring the regulations to the original hearing.
Yes, in short. And my lady will appreciate that a reasonable proportion of the cases that have been prosecuted by those who instruct me thus far relate to top-up fees and mixed fees. And of course there are cases in the wings waiting to be heard.
But no one's actually really scrutinised.
No. Well, let me caveat that. No one has scrutinised these regulations in a court of law.
No.
There is plenty of literature, academic literature. There are pieces in the dentist equivalent of the BMJ on this question, but those pieces of review are all predicated on the way in which I have sought to
So they start
define.
their analysis and discussion
Exactly.
from you're not allowed top up,
Exactly.
as opposed to there being an academic analysis of the sort that you're conducting for us this morning.
Exactly. Well, my lady,
I think we've got your
I don't think I can
analysis.
bring out another example from the hat to make it any better. Can I deal with the next two grounds?
Of course,
And then I will
we're-
come back to those questions that have been,
certainly.
if I may.
Anything at the moment you want?
No, no,
We've-
fine.
Yes, ground two.
Ground two, which I can deal with, I think, very shortly. Really picking up on the point that my lady has made just now. The hearing below ended up with a judgment which, as everyone recognises, is a radical reinterpretation of the regulations which have been in place since 2005. And as you know, the interpretation of those regulations was not a live issue either in front of the Professional Conduct Committee or in front of Mr Justice Richie. Perhaps the way in which it became a live issue was unfortunate for all parties, because, as I understand it, it was raised by the judge on the second and final day of the hearing. And what happened, and I wasn't there, Mr Keller was, and he will correct me if I'm wrong about this, but what happened was that Mr Keller, quite properly, because it was not part of his case or his instructions, didn't, as it were, take the invitation proffered by the judge to make these points as to the definition of part of a course of treatment. And so what happened is, after the conclusion of the hearing, the learned judge asked for copies of the regulations and one or two other documents. Those were provided to him by way of email, coupled with the joint supplementary note, which you will have seen in your bundle. Now, of course, I accept the legal proposition set out in Mr Vinnell's skeleton argument as to the propriety of the judge of his own motion raising an issue such as this, and inviting counsel to comment on it. My submission would simply be this, that given the real importance of this, not just to this case of Miss Williams, but to the profession as a whole, given the huge ramifications of any new interpretation, what, with the benefit of hindsight, should have happened is that counsel were invited back to make oral submissions to the judge, possibly even considering the calling of expert evidence. That didn't happen, and in my submission, although the joint note is clearly designed to assist the judge, it's not what you would call, with no disrespect to the parties, a fully blown submission on the correct interpretation of these regulations. And again, absolutely with the benefit of hindsight, perhaps that is what should have occurred, given the importance of this point. That's all I wish to say about
No,
ground
that's
two.
most helpful. Ground three.
And ground three, dishonesty. Well, again, I think I can deal with this relatively succinctly, because you will have appreciated from the judgment that the judge's interpretation of the regulations was, in my word, pivotal to his decision on dishonesty. In Mr. Keller's word, in his skeleton argument, material to it. And the submission really can be distilled as follows. If this court finds that the PCC's interpretation of the regulations was correct, and that they were further correct in describing it as a fundamental tenet of the profession, then once you put that back into the equation, in our submission, the findings of dishonesty must stand.
Judge, the difficulty with that, speak for myself, is that the judge said, well, if I was wrong and that the regulations are ambiguous, then that's a factor, and then he sets out other factors.
Yes.
Speaking for myself, I'm not going to dissent from the judge's view that they're ambiguous. I mean, we may conclude that the PCC's interpretation is correct, but they're not clear.
I think everybody has agreed that they could have been drafted more precisely than they were, and I'm not going to dissent from that proposition.
And so therefore one has sympathy, again speaking entirely for myself, one has sympathy with a first instance judge saying, well, at the very least they're ambiguous, and that factors into my consideration of the, in that sense, the separate appeal about dishonesty.
Yes, I suppose there's a tension, I absolutely take that point, there's a tension between lawyers looking at the regulations and concluding, as I think everyone does in this room, that they are, let's use the word ambiguous, as opposed to practitioners who have had the benefit of the profession's interpretation and advice since 2005, which, rightly or wrongly, was not ambiguous. But perhaps that's a rather fine point.
Well, it may not be a fine point, Miss Johnson, but is it a wholly fair one on the facts of this case? You have a young dentist who has done a training year in a purely NHS practice. She walks into an environment which on any view was unsupportive and difficult. She receives no proper training. When she goes back to her original trainer says you can't do this, and she stops.
Yes.
Those are all factors to which weight should have been given.
Absolutely. I accept that, but I would just put these factors, as it were, to place beside them, and obviously it's for the court to weigh those up. you are quite right, my lady, about her training being relatively recent. I would simply make these points, they're facts, whether they have any weight, matter for the court. First of all, she was a full-time dental nurse and practice manager from 2000 to 2010, which of course you will appreciate straddles the introduction of these regulations. It is absolutely right that she was a relatively recently qualified dentist, but you will further recall that she'd taken up a position in her mother's former practice, and it is clear that her mother was a very experienced dentist of long practice. As to the point
Her
about...
mother was no longer there. Her mother
No,
had
no,
gone,
absolutely.
and in her place was someone who was clearly unsupportive.
Clearly,
She was working under a huge amount of pressure.
yes, clearly unsupportive. Insofar as that individual is concerned, Mr. Keller makes certain remarks in his skeleton about that. All I would say to, as it were, balance it a little, is that the PCC heard evidence about the NHS dental activity review at that practice, and that review, and I quote from the judgment, did not see evidence of a culture of inappropriate NHS claims at the practice. So I just simply put that into the mix. Yes, there was a personal and professional tension, but there wasn't a culture of inappropriate claiming by that individual or the practice. You will, of course, you make the point, my lady, quite fairly, that as soon as she was told this was wrong, according to understanding, she stopped. That is a point in her favour, but it is not perhaps determinative. Really, in our submission on dishonesty, it all hangs with the correct interpretation of the regulations, and if the PCC were correct, then in our submission, the PCC were entitled, given all the other factors that they took into account, to infer dishonesty.
It's sort of saying it's dishonesty by strict liability.
No.
Well, if effectively none of the factors my Lady Justice Davies has highlighted don't go objectively to the
Forgive me, I'm not.
Then
No, I'm not suggesting that. I'm just suggesting that if you take the regulations out and the PCC were entirely wrong, then it's a very simple answer as to dishonesty or not. If you put the regulations back in, then my simple submission is it's a more complex question to determine. And that although this court may feel that you would come to a different conclusion, if the regulations have properly been interpreted, then I would submit that it would be too far to suggest that the PCC could not infer dishonesty. Whether they were right to is another matter. So I certainly do not want to be as blunt as perhaps my submissions have been misinterpreted. And I simply make the obvious self-evident point that the PCC did, of course, have the benefit of hearing from Miss Williams and assessed her credibility as such. And finally, of course, this case is entirely concentrating on top-up fees, but one looks at the determination as a whole. Dishonesty was found in relation to another feature which doesn't touch on what we're dealing with today in terms of the top-up fee regulations. My lady, that is, I think, all I would wish to submit at this stage. Appreciating, of course, the one or two matters I need to research.
No, thank you very much indeed, Ms Johnson. That's most helpful, and you've warded off all our questions with considerable skill and good humour. Thank you.
My lady, my lord, it's been agreed subject to the court that I'll go next.
Certainly.
I appear as advocate to the court,
Yes.
hopefully to assist the court in relation to arguments that could be made in favour of the judge's construction of the regulations. Because I'm here to assist you, I'm not going to present those arguments entirely uncritically. I'll try and identify where there might be difficulties with them as well as otherwise. Before I get started, a couple of references on the questions that have come from the court this morning. In terms of, first of all, the question about remissions for children and pregnant patients and things of that nature, I think the answer is Regulation 7 of the Charges Regulations. That refers, which is in the at page 134, and that was what you were showing.
Yeah.
7.1, it's a bit complicated this. 7.1 refers
No,
to
really?
Schedule 12ZA of what turns out to be the NHS Act 1977. The relevant provision is now section 177 of the NHS Act 2006. And there's another act called the NHS Consequential Provisions Act 2006, which means that these 2005 regulations now apply under section 177 of the new act. And that section 177 is a regulation-making power, but it says that the regulations can't impose charges on certain categories of patient, including, as I said, children, students, pregnant patients. What I've not been able to find this morning is provision for people who are on, for example, universal credit, as my Lady Justice King raised.
Well, maybe wrong. It just, that was a presumption on my part, not based on any knowledge.
Yes, well, that's as far as I've been able to get with that one.
So that's how Regulation 22.2 works. That's why it's an exception. It's all a bit convoluted, but
Well,
that's why the NHS charges regulations are an exception.
Yeah, I mean, Regulation 22 is not a ban on mixed charging, it's a ban on charging.
Yeah.
And then the exception is, but you can obviously charge the statutory fixed charges. So that's why it's an exception. I mean, I don't think that's in dispute between anybody. The second preliminary point, I think it was my Lady Justice Davies who asked whether the UDAs were broken down. And was it? I
Doesn't
apologise.
matter.
Anyway, the answer is AB 62, Authorities Bundle 62, which is Schedule 2 to the contracts regulations.
Sorry, Mr. Warren, give me that page again.
62, my lord.
Oh, there we are, units of dental activity.
And you'll see that this is done by reference to the 3 charging bands in the charging regulations. And if you look at the definitions section, there's a cross-reference over to the charging regulations. But no doubt you're already there at the top of 63. It says band 3 course of treatment, 12 units. It's not broken down. And I'll be coming back to this point, but what the court, I'm sure, will appreciate is that is the same whether it's 1 crown or 5.
Really?
Yeah, and that's a
I'm
point
talking
that
about risks
Mr
of
Justice
integrity.
Richie. That's a point that Mr Justice Richie made. If you give me a moment and I'll find the reference. Yeah, it's 121 in the judgment. Provided they all form part of the same course of treatment. You do 1 examination, there are 5 teeth here that need crowns. That's 1 lot of 12 UDAs and 1 £200 band 3 charge. It's not £200, it's is Regulation 4. At the relevant time, they were 24430. So, my ladies and my lord, with those out of the way I was proposing to deal with this is, first, you'll have seen that in my skeleton, and this structure was also adopted by Milena from Ms Johnson KC, there are two separate arguments. Is it an exception to the principle that you can't charge for stuff that's on the contract? We call that argument A. And the second argument is, assuming you can't charge for treatment that's on the contract, can you take a part out of, well, obviously you can take a part out of the contract, but what are the limits on your ability to do that? And can you use that power to create a similar result, to create the top-up fee result? So in terms of structure, I'm first going to deal with what the judge decided, whether he relied on argument A or argument B. I'm then going to tackle argument A, I'm then going to tackle argument B, and then I'm going to say a few words about policy, and then I'm going to very briefly make some observations on ground 2. So to start with that structure, my lady and my lord, what were the judge's reasons? How did he get to where he got to? And I've summarised the judge's reasoning, hopefully accurately, in paragraph 5 of my skeleton argument, which is in the supplementary bundle. Supplementary core bundle, it gets a bit confusing. And it may assist the court if they could have the bundle with my skeleton open, but also the judgment open, because I'm going to be nipping between them. The judgment is in the core bundle at page 108. So the first point that the judge makes at paragraph 71 of the judgment, after quoting Regulation 22, and that's on page 108 of the core bundle, is the ban on mixed funding, which is how he characterises Regulation 22, is subject to an exception, namely if the charges regulations permit charging. This they do, and we know that, and that's not controversial. And then he goes on at 73 to say that paragraph 10 of Schedule 3, quote, second line, clearly states that mixed private and NHS funding is permitted for, quote, any part, unquote, of dental treatment if the arrangement is agreed with the patient. Therefore, I so rule. And he makes similar observations at 96 and 97, where he says that that paragraph permits mixed charging, expressly permits agreed voluntary mixing. So, up to that point, read in isolation, it sounds as if the learned judge is saying that paragraph 10 permits mixed funding of services provided under the contract. In other words, argument A. Top-up fees for NHS services. That's further supported by paragraph 71 that refers to a ban on mixed funding as a reference to Regulation 22. And when we see what Regulation 22 actually bans, 22.2a, it's charging fees for treatment under the contract. And it's also supported, in my respectful submission, by paragraph 72, where he introduces paragraph 10 of Schedule 3 with the words in addition to the fixed charges and charges regulations, and they obviously are an exception to the no charging for services under the contract rule. And then again, 73, as I've already said, does look as if the judge is saying that this allows, quote, mixed private and NHS funding for any part of dental treatment. So mixing within the part. But there are, in my submission, indications pointing the other way as well. There are two reasons I'd like to bring to the court's attention to think that perhaps that isn't what the learned judge had in mind. The first is the language of paragraph 10 of Schedule 3 itself. And as I pointed out in my skeleton, what that actually says is not that it allows mixed funding for a part. What it says is that part of the treatment can be provided privately. And if you ask yourself, what does provided privately mean? The most obvious meaning is not on the NHS, not under the contract. So it may be that rather than indicating a misunderstanding of what paragraph 10 does, it may be that it was more in the nature of an infelicitous shorthand of what paragraph 10 does.
The infelicitous shorthand being calling it an exception.
My Lord, no. The infelicitous shorthand saying that it permits mixed private and NHS funding for any part of dental treatment.
Right, okay.
Which, as I said, indicates that it's permissible to mix the funding for however small the part is, you can get funding from two sources for that part. And the second, perhaps more important indication is paragraph 79, which is over on page 110. This is the judge's conclusion. And what he says here, it's the last bit, he concludes that a person reading the regulations would have been entitled to conclude that she could charge top-up fees for the crowns if the patients agreed to that route and she provided proper all-round advice, and so long as her clinical judgment was that ceramic crowns were not necessary for her oral health and hence not available on the NHS. So it looks as if the judge was envisaging that his reasoning only applied to additional services above and beyond what's clinically necessary for oral health.
Yep.
And if that doesn't work by taking parts out, then it's not obvious where that limitation would come from. If you can mix within a part and just charge top-up fees for non-Waitrose NHS services, it's not obvious where that limitation would come from. And to labour the point, the difference matters because if it's argument A, that's potentially a much broader power to charge top-up fees, or the ability rather to charge top-up fees. Whereas if it's argument B, it's a much narrower consequence, and it's just for the added value services that go beyond what's clinically necessary for oral health. So, my lady, my lord, I don't have a submission about which argument the judge ended up relying on. There are pointers both ways, and it's a matter for the court to construe his judgment as to which argument the judge was relying on. But I'm obviously going to address both in terms of their merits. Going on in the judgment, please. The judge went on to find that there was no limit placed on the power to mix in the contract, that's paragraph 76, and that there was no rule that the power to mix doesn't apply to work on a single tooth. And then he goes on in paragraph 77 to say that the guidance in the dental handbook ignores the permission to mix by agreement in Schedule 3. Sorry, let me start that again. Ignores the permission to mix by agreement in Schedule 3, paragraph 10.1. Now, in fairness, that's right as far as it goes. It is also fair to observe, as learning from Mr Keller has pointed out to me, that the dental handbook does refer to paragraph 10.3, even though it doesn't refer to 10.1. So that's what I wanted to say about the judgment. I'm now going to move on to address, first of all, argument A. This is an exception to the ban on charging, further exception over and above the charges regulations. Because it's not in dispute, as you've heard, that there is an ability to mix services provided under the contract with private services within a single course of treatment. And you see that not just in paragraph 10 of Schedule 3, but also, and again I'm grateful to Mr Keller, KC, for this, paragraph 7.2, which is on page 71 of the authorities binding.
Sorry, what paragraph number?
7 sub 2.
Got it, thank you.
This is all about treatment plans, but it deals with the scenario of a patient deciding to, quote, accept the provision of private services in place of or part of services under the contract. So there's no doubt that you can do that. It might, I learned from Ms. Johnson didn't make this submission, it might be said, well, that shows that that's the only way to do it. In support of argument A, I would say, well, the fact that it acknowledges that you can do that does not necessarily mean that's the only way to do it. You don't have to do it in place of. But so far as the meat of argument A is concerned, whether the only exception to the no charges for contract services rule in Regulation 22 is the charges regulations, or whether paragraph 10 is a further exception, there are 2 points for the court to address in my submission. The first is whether they can be an exception, given that there's an express exception for the charges regulations, and in Regulation 22(2)(a), but no express exception for other provisions of the contracts regulations. And in my respectful submission, that's not determinative. You've got to read the contracts regulations as a whole, and if, on their true construction, they provide for a further exception in paragraph 10 of Schedule 3, then it must be given effect to. So the real question in my submission is whether paragraph 10 in fact does provide for a further exception to the no charging rule. And that, in my submission, turns on what provided privately means. because if provided privately means provided outside the contract, then the court might well conclude that paragraph 10 is not on its face an exception to the no charging rule. It's the other side of the coin to the no charging of services in the contract, but you can charge for things that are not in the contract. But the court will want to consider whether provided privately could have a wider meaning, such as, for example, partially funded by private funds.
But provided privately is concerned with the services.
Yes.
It's rather coy for another side of the coin. You've got all this stuff about money, the charges on the one hand of the coin, but you turn it over and it's the provision of services provided privately.
Yes, I suppose the drafter of the regulations might say this is all about what can be charged for services provided under the contract. That's what Regulation 22(2)A applies to, and it's none of my business what gets charged for things that are provided not under the contract.
Right.
And
Could have said paid for privately.
it could.
Yeah.
Well, I suspect that Ms. Johnson would say it's very important that it doesn't, because the two must go hand in hand, is what the General Counsel would say, is that you can't have things provided on the NHS but paid for privately unless they fall within the charges regulations.
Yeah.
Sorry, I expressed that badly. You can't charge for what's provided under the contract unless the charges regulations allow you to. Is a better way of saying it. So that's all I wanted to say, my ladies, my lord, about argument A.
So you're on argument A, in a sentence, you say, and you're focusing on these words, and that's the first time we've considered it, but obviously we've noted it in our preparation, provided privately.
Yes.
Very good.
Argument B, which is whether you can use the undoubted ability to provide part of a course of treatment privately to create a top-up fee permissive arrangement. So there's no doubt that there is a power to provide part of a course of treatment privately, and it is described in broad terms. Any part of a course of treatment is what paragraph 10 says. Couldn't be broader in my submission. So to take an easy example first, and this is the example I give in my skeleton argument, you might have either a tooth that needs filling and a tooth that needs a crown, and you might reveal in a single examination, so forming part of the same course of treatment, but the patient might, for whatever reason, give informed consent to the crown being private and the filling being NHS. Nothing wrong with that. And I go on to say in my skeleton that there's actually no reason why, given the right circumstances, you couldn't have two such distinct treatments on the same tooth. There's nothing in the rules that says you can't. The more difficult question, and I know the one with which the court is interested, is whether the power to mix can be exercised in such a way that different elements of a single procedure are treated as different parts of the course of treatment. And at paragraph 16 of my skeleton, I make a number of points that could be made in favour of that. The first is the one I've already made, which is that any part is wide in its own terms and there's no express limit on it. The second point I make is that you could have a distinction between parts and labour. And I want to spend a bit of time on this because Ms Johnson addressed this in some detail. The first point that was made by Ms Johnson is, how does the patient know which is private and which is NHS? And in my respectful submission, there's a very simple answer to that, which is they have to know, and you have to explain it to them very clearly, because if you don't, they haven't given the necessary informed consent.
And that was the point I was making to Ms Johnson.
My lady, yes, I respectfully adopt what your ladyship said. And furthermore, there is an express provision in paragraph 10.3, which I would ask you to turn up. It's page 73, which said, so the contract must provide, among other things, that the contractor shall not, with a view to obtaining the agreement of a patient to undergo services privately, advise a patient that the services which are necessary in his case are not available from the contractor under the contract, or B, seek to mislead the patient about the quality of the services available under the contract.
So there we have in regulation form my observations about professional misconduct.
Quite so. So there's very strict, I mean, you'd expect them to be there, and
Yep,
you'd
of course.
expect dentists to behave in that way, but that restricts the dentist's ability to upsell services which are not clinically necessary when in fact, services on the basis that they are not clinically necessary when in fact they are. The next point, which again I think fell from my Lady Justice Davies, was whether you could separate the preparatory work. And the answer that was given was essentially, well, that's not on the menu. The charges regulations provide a menu of services, and you're stuck with the things that are on the menu. But in my respectful submission, that can't be right, and the reason it can't be right is Regulation 4.8, which is on page 129. Which is a residual power. The very bottom of page 129. So this is, we looked at this before, it's got all the charges on and how much they are. But there's a residual power in 8 for the Secretary of State to determine charges for off-menu services.
And that would
Sorry,
make
what
sense.
services? Sorry.
Off-menu, it's not a technical
I'm sorry, I was looking for the words there.
Services which are not specified in any of the schedules to the charges regulations.
I understand
That
your
would make
assurance.
sense, wouldn't it? Because otherwise, you're just on these very straight tram lines, which now allow for no deviation at all, which in the end may not properly cater for a patient's individual needs.
My lady, yes. So that's parts and labour, which it's fair to say is not on any view what happened here. What happened here was something different, where the charge was for the difference in lab cost, as I understand it, between the minimum crown that was clinically necessary, the cheapest crown that was clinically necessary, and the crown that the patient actually wanted. And what one has to do to make this work in my submission is one has to define part in a slightly artificial way.
So are we now on to C?
Yes. Because there needs to be a part of the course of treatment that is provided under the contract so as to generate the 12 UDAs and to generate the band 3 fee of £244.30. But there also has to be a part that is provided privately. And in my submission, the only way that one can do that is by treating the part that is provided under the contract as a notional porcelain crown. And the court may think that the obvious riposte to that is, well, you didn't provide a porcelain crown under the contract, so you can't have 12 UDAs as if you did. But that is doing the best I can in my submission, the best way of conceptualising the ability to remove part of the course of treatment in a way that justifies top-up fees.
But that, I understand what you say about the potential artificiality of that. On the other hand, that is a real world point, isn't it? Because you will have cases, I'm sure it happens a lot, where a lesser type of treatment, possibly I don't know, a porcelain crown or something, is clinically necessary, but the last gasp, the Waitrose version, is not.
Absolutely.
And so then the question then becomes, should the whole thing be thrown out, or are you entitled at least to some of it on the NHS, even if you agree to pay privately for the rest?
Absolutely. And
that's must be a real world issue.
well, the submissions that were made on behalf of the General Counsel were is they spend a lot of their time disciplining dentists in just this kind of territory.
Yeah.
And their position is it's all or nothing.
Yeah.
And if you don't like what the dentist is willing to provide you on the NHS, the whole part, whatever that part is, but not divided as finely as I've suggested, has to be private. And I was going to address this when we got to policy, but I'll raise it now. The evidence in this case was that I'm sorry, my lady, my lord, give me a moment. Yes, if you turn up page 60 of the supplemental bundle, the evidence in this case was that 2 private crowns might cost the patient £900.
Can I just ask
This, because we're fresh into this, so you may well tell me that I'm getting an appalling muddle. So on page 63, you took us to band 3 course of treatment. There's your 3 UDAs.
Yes.
And what you've just been helping us with is the impact if it's, that would be for porcelain crown, but actually they wouldn't be getting a porcelain crown because they'd be getting a crown that then was topped up to make it a ceramic crown, all right? But if we look at page 157,
Still in the authorities bundle.
yes, and we're into the Schedule 3, Band 3 charges, provision of appliances.
Yeah.
If E, and we don't know yet, because Ms Johnson was going to constructions. If ceramic crown fits in E, does it matter whether it's a porcelain or a ceramic crown that's fitted?
Well, I think that's Ms Johnson's point, which is that the only service on the menu is fitting a crown. And it can be a gold crown or a palladium crown or a ceramic crown or a porcelain crown. But that's what you're getting on, and you're either getting it on the NHS or you're getting it privately. It can't be both. And my answer, insofar as I have one, is to make this this distinction between the provision of a notional minimum service on the NHS and the added value privately. Does that answer your ladyship's question?
I'm not sure, I need to think about it. I mean, you have answered my question, where it takes me, I'm not sure yet.
Mr. Keller, can I just come in slightly left field on this? But just going back to the point I was seeking to make with Ms Johnson, that you can have, if you like, the preparatory part of the procedure, and you've shown us a provision which you say could, it's page 129.48, could bring in the preparation work and be charged for, and then the crown can be done privately. We all know the case of Montgomery and how it moved away from the case of Sidaway, recognising the autonomy of the patient, and that is very much the way the whole issue of consent has gone. So critical to this process has got to be a formal and appropriate consenting process, such that any consent obtained is fully and properly informed. In properly informing any patient, what there must be recognition of is the autonomy of that patient. And it may well be said that in recognising the autonomy of that patient, that better reflects what you have recently been submitting to this court, which is you can separate preparation out from the final crown and bring it within 4.8, and then acknowledge the autonomy of the patient and allow that patient to pay privately for that last part.
Well, milady, 2 points on that, if I may. The first is I've already shown you Schedule 3, paragraph 7.2, but I'm going to show it to you again, because that is what sits underneath the practicalities of getting consent to taking a bit of treatment out of the contract.
Just take us page number.
71, my lady.
Thank you.
So you give them a treatment plan, 7.1. And then if you want them to sign off on parts of that treatment plan being provided other than under the NHS contract, you have to ensure that they sign the treatment plan in the appropriate place to indicate that you've understood the nature of private services to be provided, that you're accepting them. So there's a clear mechanism for that to happen. And that obviously doesn't answer my lady's question about how you can split up the services. I said I was going to have 2 points.
If it's of any help, I've just written little 2 down, and my pen is poised.
Yes, I think that the second point is simply this, which is that obviously autonomy is a matter of great importance in the medical and dental field. I suppose the limits in medicine as in law, there are limits to the amount of autonomy you get if you can't pay for it. But yes, in terms of the charges, we were if we can just look at tab 3, paragraph 4 again, just so that you can see how this works. Page 129. Because I submitted earlier that it didn't matter how many crowns there were. Where that comes from is Regulation 4 of the Charges Regulations. So if we look, for example, at 4.3, Band 3 charge may be made and recovered in respect of any course of treatment, one or more of the components of which are set out in Schedule 3. And that then, we've seen how that reads across into the contracts regulations and the UDAs. And the court may think that the fact that it's not just £1, one fee, one lot of 12 UDAs, indicates that the argument that was made on behalf of the General Counsel that a part of a course of treatment must correspond to a menu item can't be right, because the charges are not per menu item, they are per course of treatment. As I said before, but just to deal with the point in a little more detail. If we can turn up the Band 3 menu, which is at 157 in the authorities bundle. 157, I'm sorry, we've just gone away from Regulation 4 and we do actually need to go back there. Can we go back to, if you put your finger in 157 and go back to 129. The words that appear in each of the first few sub-paragraphs of Regulation 4 are course of treatment, one or more components set out in Schedule blah, provided as part of relevant primary dental services. And relevant primary dental services are defined on page 124. And perhaps unsurprisingly, they include, among other things, services provided under a general dental services contract. So the argument against...
Sorry, I'm just... Sorry. Relevant primary dental services, you say that crops up.
That's
in
a
those early paragraphs of 129, which is Regulation 4.
Yeah.
And you say that's defined, what was the reference?
124, my lord. Halfway down the page. And it's Little Roman 2 that we're interested in.
Yep.
So the argument against me would be, you haven't provided this porcelain crown under as relevant primary dental services, so you can't charge the Band 3 fee. The only crown you've installed is one which ex hypothesi you're providing privately because you're charging for it privately. And the thing that you're notionally, because there have to be two parts, there has to be an NHS part and a private part And in order for there to be any content at all in the private part, that then strips out of the NHS part the bit that would get you into band 3. And you can't use a notional crown because that hasn't been provided as relevant dental services. That in my submission is the difficulty with the argument that I have set out. Can I move on, my ladies, my lord, to deal briefly with policy? There's no dispute that the general principle of NHS dental services is as set out in the statutory provision that my learned friend Ms Johnson showed you. And the purpose of the no fees principle in Regulation 22 is to make sure that that happens, and that the prescribed fee in the charges regulation is what you pay for NHS treatment. The dentist can't ask for money on top for what you should be getting at no additional charge. So if you're getting, if there's no question of added value, just getting your tooth pulled out, if you're getting that on the NHS, there is a clear public interest in the dentist not being allowed to say, well, I'm going to do it on the NHS, but I want an extra 50 quid because that's our tariff for doing this, because we're a Waitrose type dentist. And it's in my submission, that is the core of what Regulation 22 is doing. It's prohibiting top-up fees for NHS services if and insofar as it restricts charging for added value extras that is a marginal effect, not the core of its purpose. And I do want to address, I know that my Lord Justice Coulson has addressed this already with my learned friend, but the submission at paragraph 30 of the General Counsel's skeleton, that it would be contrary to the purpose of the regulations for to pay an extra fee for something available on the NHS. Well, my submission would be that something available on the NHS is doing an awful lot of work in that paragraph, because, as we've seen from the evidence in this case, if you ask a dentist for a full ceramic crown, and in their clinical judgment you don't need one for clinical reasons, you're not going to get one on the NHS, whatever the regulations say, because of the way that because they don't have to give you one, and because of the way that the funding works, there's no incentive for them to give you one. So the choice, if the law is as the General Counsel says it is between being happy with what you're given, the porcelain crown, or having the whole lot done privately, and I've already referred you to the cost of that in one case, even though you had a clinical need, and that if you didn't want the extra value added element, you'd have been entitled to have that publicly funded. You lose that benefit because you want the extra little bit on top. And I would ask the court...
Can I just ask one question? You might not know the answer. Is the use of ceramics, or the clinical need, is that normally cosmetic? And I use that in the broadest terms, because it can be in your mind, it can be a psychological reason, but ultimately that's cosmetic because they can't bear the thought of it not looking right or.
My lady, I don't know. The judge did address this point in his judgment.
I'd forgotten that.
Um,
Thank you. Just remind me, would you?
I will, but I'm going to need a moment. Yes, 67, which is on page 106.
So that was my problem thing because that's what I'd got from that was the oral health, but I'd picked up from Ms Johnson's submissions that it might be that oral health was often interpreted as cosmetic. If it was a front tooth, I think was an example she gave, or psychological reasons.
I can't assist you with the court any further than that, my lady.
I'm just thinking this can be a huge area of discretion for a dentist if you're often thinking in terms of cosmetic.
I can't properly make any submission about that, my lady.
So the submission you're making is the baby out with the bathwater point.
My lord, yes. And many of the evils that were conjured by my learned friend about bringing in this element of commercial discretion and creating health inequalities are there in spades if you won't provide anything on the NHS. And you don't just have to pay a top-up fee if you want the extra bit, you have to pay full whack. And what is the point? What is the public interest that is being served by saying to a patient in the situation of patients T, U and V, if you want a ceramic crown, you've got to have it wholly privately. It's clear what the incentive is. It incentivizes people, if they can afford it and they really value the ceramic crown for whatever reason, to not take advantage of the public funding that would otherwise be available to them and pay fully privately for the crown. Perhaps that results in an overall saving of public money, but it does so at the expense of a patient who is admittedly in clinical need of a crown of some sort. And it also, as my Lord, I think Lord Justice Coulson said, because there is a discretion for dentists to provide a ceramic crown on the NHS if they are willing to take the economic hit of doing so, because they have to pay the lab fees and the lab fees are more, then they can. So the disparity is between my Lord Justice Coulson, whose dentist says, no, it's not worth it for me to provide you with the ceramic crown that you want, and my Lord's friend down the road, who's got a more accommodating dentist, who will happily provide one on the NHS. And that is essentially the point that the learned judge made at paragraph 68 of the judgment, page 107. Which is this: the alternative, which would have been worse for the patients, would have been for the appellant to have refused to provide the ceramic crowns on the NHS, and I think this must be...
They were not.
Yes, exactly, because they were not needed for oral health, and to have advised the patient that they could only buy them privately from a private dentist or indeed pay for them privately at the appellant's practice. that would have cost the patients considerably more. And in my respectful submission, that's obviously right, and it's not obvious what public interest is served by that. And the judge comes back to the point at 94, where he says that one way of satisfying the patient's need for a better crown, while also saving money for the NHS, is to charge the patient a top-up fee.
Mr. Ryan, what my understanding is, and you may not be able to help with this, but my understanding is that before 2006, there were different fees for different crowns, and then it was made uniform by the banding process. And so, on one view, when that sort of thing happens, courts tend to say, well, it's swings and roundabouts. But on one view of this, the dentist can say, well, I'll keep the swing, but if you want the roundabout, you have to pay privately.
My lord, I'd adopt that, yes. Two short points to finish this point. The question was raised, well, who's liable if something goes wrong? There might be difficult edge cases. Well, that's what the courts are for. Courts deal with difficult edge cases all the time. And the other point, and I've made this already, the point about perverse incentives for the dentist to provide substandard, to offer clinically necessary services as if they were an added value service. And I've shown the court 10.3, which for what it's worth addresses that. That's all I wanted to say on the main, on ground one. I wasn't proposing to say very much at all on ground two, other than there doesn't appear to be any dispute about the law. I put the cases in my skeleton argument. I don't propose to take you to them because the principle seems to be agreed that a judge can take their own view of the law, provided they act fairly to the parties. And I'm not going to make any submissions about the facts of the case because the parties are here. I just wanted to draw the court's attention to the relevant paragraphs of the judgment where the judge explains what he's doing and why he's doing it. The core is 109, and I don't have a page reference. 119, thank you. Where the judge notes that there was no ground of appeal about this.
So what paragraph are we on?
109, my lady.
Thank you.
He said he considered himself to be duty-bound to consider the issues raised because they affect the validity of the foundations for the PCC's decisions on dishonesty. And there's no dispute that he was right to treat the appeal as a rehearing because that's what the practice direction says he had to do. And given that the battleground before him was the sustainability of the finding of fact that Ms. Williams didn't know the rules, it wasn't surprising that the judge would want to know, well, what rules? What do they look like? He was entitled to do that in my submission. And further, he makes a very similar observation to that at 69. In my judgment, to determine this issue, the PCC should have been shown all the regulations allegedly broken. And again at 98, where he says it's not fair to make a finding that a professional has breached a regulation without stating accurately which regulation was allegedly breached. So the judge needed to get into the question, to understand the underlying law, and having embarked on the exercise, in my submission it was open to him, subject to acting fairly, to take that exercise to its conclusion and to reach a view about what the regulations meant. So, my ladies, my lord, unless I can assist the court any further, those are the submissions that I was proposing to make. And I'm sorry, I'm 2 minutes after 1 o'clock.
Thank you very much indeed, I'm very grateful. Over to you after the short adjournment then. Very well, thank you all very much. 2 o'clock, please.
Of course.